Of course, all eyes on the White House and the U.S. Supreme Court as there is a vacancy now. And joining us on the phones to talk about what the administration will be doing and also how this may impact even the campaign. Senior legal advisor to the Trump 2020 campaign, Jenna Ellis, joining us here on the Chad AC Show. Jenna, good morning. How are you today?
Good morning. Thank you for having me.
Absolutely, great to have you on the program today. It's been interesting the last few days. Democrats not too happy with President Trump and the constitutional requirement that he has to fill a seat on the U.S. Supreme Court. Walk us through kind of what the process is going to look like and how it may play out there in Washington.
Yeah, well, you're right that the Constitution does provide a very straightforward process, that when there is a vacancy on the federal bench, and that includes any of the Article III judges, including the Supreme Court, so when there is a vacancy, then the president shall nominate someone to fill that vacancy, and then the Senate will provide advice and consent. And so the president will nominate his selection to fill that seat on Saturday at 5 p.m., and then the Senate will take that up, and they will provide advice and consent. And the way that they do that now in the current era is through confirmation hearings through the Judiciary Committee, and then going to a full vote. And so in this era now, Republicans only need 51 votes in order to confirm that nomination. And so that's the process. And, of course, Democrats have been challenging that and saying, oh, well, this isn't in 2016 and, Obama's last year before the election, the Senate wouldn't even consider Merrick Garland. That was his nomination. Well, that was the Senate doing their constitutional job by providing advice, and they said, we don't consent, and so we're going to keep that open. So that's been the constitutional process, and it will continue. And it sounds like from everything that the Senate is saying with Mitch McConnell, Lindsey Graham, everyone there, that Republicans do have the majority and will have the vote to confirm.
And you look back at 2016, and the news media likes to forget about this. Democrats like to forget about this. But even what Mitch McConnell did and the Senate did in 2016, there was precedent for that. I think even in one statement that he put out this weekend, it had been since the 1800s, since when a seat opened up in a presidential election year, Senate controlled by one party, the White House controlled by another party. It just doesn't happen. That position is not confirmed. But you go back where I think there have been 27 total cases during a presidential election year where you've had a seat open up on the U.S. Supreme Court, and when the parties are the same, those seats are normally confirmed, correct?
Yeah, and that's all true, and that's history. But in terms of the law, that type of precedent doesn't even matter. What matters to the Constitution is that the Senate provides its advice and consent, and that's the only constitutional rule. So, if everybody's saying, oh, this is precedent or not precedent or whatever, all of that actually doesn't matter to the law and the Constitution. And so, so for everyone who's trying to say that Republicans are hypocritical or, this and that, not only does history suggest otherwise and show otherwise, but the Constitution itself allows for this, and Mitch McConnell and the Republican-controlled Senate, they get to provide their advice and consent, period.
Does the president want a speedy confirmation? Like, does he want this to happen before the election or after the election, or is that going to be up to the Senate?
The process is entirely up to the Senate, and the president trusts and has confidence in Mitch McConnell and the Republican-controlled Senate that they will do this expeditiously, and they will also give his nominee due consideration and go through that process to fill that seat as expeditiously as possible.
Do they have to have hearings?
They don't have to. Again, the Constitution is silent on that, and how the Senate provides their advice and consent is up to them and according to their Senate rules. And so they could have hearings that are very quick. They could decide to just call the floor vote. I mean, that's according to their own rules, and how they do that process is entirely up to the Senate.
Well, it's going to be certainly something to watch. There's going to be a lot of rhetoric on both sides, but I think, like you said, the most important thing to look at, and this is what the president cares about. This is, I think, what Mitch McConnell cares about as well, and what we should all care about is the Constitution and what the Constitution actually says, not someone's wish, not what Nancy Pelosi wants, not the threats from the Democrats. It's what the Constitution says. That's what actually matters.
Yeah, absolutely, and that's what absolutely matters as well to filling the seat in terms of what the justice's own obligation is, and that's why we need a conservative majority on the court, not an activist court, so that they're not looking at other types of things. They're looking only at the Constitution and applying fairly and appropriately the rule of law.
Talk about that just for a minute or two. What if a strict constitutionalist is confirmed to the Supreme Court? Obviously, that's going to change. You would think the direction of the court for a number of years, something the Democrats aren't happy about. But what would that mean for this country moving forward for the next, 20 years or so?
Well, looking at our system of government, the whole point of having a judicial branch is that it's non-political. It's not supposed to be activist. It's supposed to interpret and apply the Constitution fairly and accurately. Originalism is and textualism, and you're going to be hearing these words over and over as we move through this process, but it's basically the idea that the justices don't get to substitute their own opinion for the written word of the Constitution and applying that. And the purpose of government, as we see from our Declaration of Independence and then the Constitution itself, is that our founders recognize that our rights come from God, our Creator, not our government. They pre-exist government. They're endowed because we are human beings made in the image of God, and we have our rights that are guaranteed through our Constitution, because our founders recognize that the sole purpose of government is to preserve and protect those rights. And so if we take the Constitution in context, then it only provides specific limited powers to the branches of government that are separated, of course, to operate according to that purpose. And so the legislature makes law, the executive executes the law, and then the judiciary makes sure that the legislature and the executive don't overstep, that they stay within those margins, that they're faithful to that purpose of government. And so that's not what the Democrats, that's not what the extremist left wants. They want activism. They want to twist and manipulate or even ignore the Constitution completely in favor of their own opinion. And so this will be an incredibly important and significant majority moving forward to correct, I think, what has been an overbroad and activist court for the last 50 and 60 years. Yeah, absolutely. I'm with you on that one. Jenna Ellis, Senior Legal Advisor to the Trump 2020 campaign. Appreciate your time today. Let's visit again soon. Thank you.
Thank you. That's Jenna Ellis with the Trump 2020 campaign, Senior Legal Advisor to the Trump 2020 campaign.